Excellencies, ladies and gentlemen, thank you for inviting me to this conference and giving me the opportunity to discuss subjects I consider of the utmost importance, namely gender equality and shared parenting. As a former Minister of Gender Politics, I have always fought for equality between genders at various levels. At work, equality of the sexes at all steps of the career ladder, including part-time work and parental leave for both. In politics, balanced voter lists, mandates for both sexes. And in the family, shared responsibility, mutual respect. I am fundamentally convinced that if we succeed in achieving a balance at these three levels, we will also succeed in achieving a better work-life balance. Let's consider gender equality first in the business world. Studies show, McKinsey for one, that companies would benefit from gender equality and clearly describe the added value of a greater mix at all corporate levels. In addition, and here I am also sure, companies which are not able to offer their employees high wages might manage to score points with employees by offering flexible working hours, and in this way such companies won't just win over employees but also bind them to the company. Contented employees are of course loyal employees. It's a win-win situation. In the political arena, this means that women and men, through their different complementary perspectives, can make better decisions for the general public and the common good, and can also take more targeted account of the needs of the population. Third level, the family policies. Concerning family policy, we would like fathers to continue to invest in their parental role because, again, numerous studies prove that they play an invaluable part in a child's development. So, if everyone agrees that fathers are important attachment figures for their children, then I really don't see why this role should become secondary at the point when the parents no longer get along with each other and separate. Even if a couple ceases to function as a man and a woman, the parental couple must always continue to exist in the sole interests of the children. Throughout my life and during my tenure as a minister, I have met many unhappy parents who have not come to terms with the separation, especially due to the consequences of this separation. Unhappy because their formerly happy relationship was torn apart, but also unhappy to gradually lose contact with their children. I am shocked, for example, that the prosecution of complaints is frequently not taken seriously. For example, when following a divorce, one parent refuses to let the other parent have access to the child for the weekend. Often, no sufficient action is taken against the offending parent. Things can get even more complicated when the parents have different nationalities. In addition, I have met the children of estranged parents who felt they were used as pawns in the middle of parental conflict and who even felt complicit in the separation and responsible for one or the other of the parents, but who, above all, were very sad. This is the reason why I have tackled this topic, a sensitive topic, a topic that knows no boundaries and which unfortunately leaves many unhappy adults and children in its wake. You need to know that there are around 10 million children in Europe who come from divorced backgrounds. I am not necessarily concerned here with defending the rights of fathers or mothers, but I would like to point out that it is a child's right to maintain relationship with both parents. This is set out in Article 9 of the 1989 United Nations Convention of the Rights of the Child. The article of the Convention also states that both parents have joint responsibility for bringing up their children, and both are required to ensure their development. In 1984, the Committee of Ministers of the Council of Europe suggested that the above should be perceived as an interplay of rights and duties intended to ensure the moral and material well-being of the child and to allow the continued maintenance of personal relations with them. It is also important to point out that different countries use different terms in this context, such as parental custody, sole custody, parental responsibility, guardian. And in order to avoid confusion between the terms, I would like to focus on the concept of parental responsibility, which therefore includes a whole set of duties and rights aimed at advancing and protecting the well-being of the child. As far as the child's residence is concerned, I would like to use the term double or dual residence to make it clear that this is a model where the child lives with both parents. I define this kind of residence as an arrangement in which the children of separated or divorced parents spend about the same amount of time with one parent as with the other. That is at least 35% with one parent, at best 50% with each. Now, of course, the question arises, which home model is most suitable for the child? The one where the child lives mainly, almost exclusively with one parent, or the one where they live with both parents, with a minimum of 35% of time spent with one parent. To come to a considered opinion on this subject, I read Dr. Linda Nielsen's study. She compiled a report of 40 different studies in this regard. Of course, there are always limits that have to be taken into account, such as the financial situation of the parents, the way they deal with each other, whether there is a high potential for conflict between the two, etc. I'll get to that later. However, it should be noted that the positive effects of double residence are highlighted in numerous studies. The children are less depressed, are better behaved, less upset since they do not feel responsible for one or the other parent, more balanced, and they often have a better relationship with both parents because they are able to communicate better with all of them. I would therefore like to say at this point that, except in a few exceptional situations for a child, double residence has far more advantages than living with just one of their parents, both in terms of the psychological, emotional and social well-being of the child. However, a certain frequency and a certain regularity of contacts are necessary for a family bond between parent and child to come about at all, a relationship in which the child feels safe and well protected. The French psychologist and clinician Gérard Poussin says, to have a quality relationship, it needs first a relationship. So if a child spends a very limited amount of time with parents, it is difficult to bond. One cannot claim to respect the place and role of the father if one does not allow him to create and maintain a bond between him and his child. But let's talk about the double residence. The double residence must be carefully organized and must take into account the age of the child. The younger the child is, the less it can bear long periods of separation. Double residence must take into account the needs of the child and must be strictly respected. The parents should agree on a progressive parental housing plan for the child and a care plan which must be adapted again and again in the context of the development and maturity of the child. However, the double residence should not be exclusively an arrangement between the parents or be regarded as their right. I think it's absolutely essential to emphasize that the interest of the child is not secondary. The child has to be involved in arranging the housing plan, if its age allows, regarding where and how long to spend time living with its respective parents. In addition, the child must be able to ask the family judge to re-examine a decision regarding residence if the child can no longer cope with the situation, and to reverse the original decision if necessary or appropriate. In general procedures, children should be heard, should be able to express their opinion, should be informed of all the consequences of individual decisions, as provided for in the European Convention on the Exercise of the Rights of the Child. The time children spend with the respective parent must be adapted to their age-related abilities and be modulated accordingly. The double residence should be a child's right aimed at having a relationship with both parents. Double residence should not put the parents' rights over the child. What is also very important is the way in which the transition phase takes place. That is the moment when the child is transferred from the arms of one parent to the arms of the other parent. This is a crucial phase for the child, who must feel well protected by both parents, feel that what is happening is good and supported by both parents. Apparently, such moments of transmission are often painful for everyone involved, and in particular when the parents fight in front of the child. I was shocked to hear that some parents insist the children change clothes before going into the ex-partner's home, so that they can take the clothes they brought the child back home with them. I am fully aware that these events are often painful because the estranged parties have to relive the breakup again, the disappointment, hatred and anger. But for the sake of the child, the parents should try to show a sense of responsibility. A question that is also frequently asked is the following: in which cases is double residence inappropriate? There are some situations in which double residence is certainly not the right way forward. Sexual abuse of children, violence, drug and alcohol addiction, or mental illness. Double residence is also not suitable, or let me say that its benefits are diminished, in cases where parents are in permanent conflict with each other, or where the relationship between the child and the parent really doesn't work, or if the geographical situation does not allow it, and it would be impossible to organize a structured life for the child. So, in which countries does double residence have a legal standing? France, for example, introduced the résidence alternée exchange model by law in 2002. Double residence is applied in 17% of divorce cases. Italy and Portugal. Here too, double residence has a legal basis, but remains marginal. Greece, Albania, Poland have no legal standing. Belgium, the Netherlands, Sweden, Norway and Germany have a legal basis. An important question is how judicial decisions are implemented. The majority of member states have provided for penalties if the decisions relating to the residence of the children are not respected. But even if the states provide for penalties, it is shown in practice that in various countries legal cases in this context are not systematically pursued. This leads to an attitude of, oh, nothing happens to me even if I don't now adhere to the agreed childcare plan. Unfortunately, court orders are all too often disregarded. The European Court of Human Rights is familiar with a large number of cases relating to the residence of children or visitation rights. Some countries have been prosecuted for not taking the necessary measures to protect parents' visitation rights. If certain countries ignore such serious disregard of judicial decisions regarding the residence of children in divorce cases, this inevitably leads to the fact that it becomes impossible for at least one parent to build a stable relationship with the child. Of course, this problem is exacerbated in the case of parents who have two nationalities. Why? Because in such cases different legislations come into play. There are cases of child abduction, And it is precisely in these cases that countries are called upon to react as quickly as possible, because the time factor plays a crucial role if the relationship with the child is not to suffer. In this context, the European Court of Human Rights emphasizes that the time lost in such cases has irrevocable consequences for the parent-child relationship when not living together. Countries are therefore called upon to implement the Hague Convention of 25 October 1980, which deals with international child abduction. This convention presupposes cooperation between the central authorities, and an accelerated procedure helps to ensure that the child is returned to its usual residence as quickly as possible. It is based on the principle of immediate return, which should have a deterrent effect. The principle aims to restore the status quo that existed before the kidnapping. Unfortunately, the European Court of Human Rights is aware of many cases where returns take an excessively long time. Mediation. The research and discussions that I have conducted to prepare the report, as well as the statements from affected parents, have convinced me that it is essential, in connection with the residence of the child, to arrange mediation in the case of family conflict management after a divorce or separation. Mediation is a means that allows parents to take responsibility by defining the living conditions of their children. In this context, the Ombudsman from Luxembourg spoke of a specially tailored model as opposed to the judicial prêt-à-porter, the 0815 formula used in divorces, which can be summarized like this. The child spends every second weekend and half of the school holidays with one parent. In most cases, this model applies to the fathers. In Luxembourg, for example, a free information session on mediation is provided. In the UK, this session has been mandatory since 2014, barring cases of domestic violence. Mediation has played a major part in helping to smooth conflict between parents and to get them to find the best possible solution in the interests of the child. No solution is imposed by a judge. It was also noted that the payment of alimony was respected more when the parents made an agreement. I would like to mention the Cochem example at this point. This model, named after a German city, comes from the judge representing juveniles, Professor Rudolph. It has set up a system of cooperation between the various judicial authorities, the lawyers, the protection of young people, and counseling centers. This system serves parents who are in a conflict situation to work out acceptable solutions. All persons involved in divorce procedures work together in an interdisciplinary manner to get the parents to talk to each other and to acknowledge that the child has to maintain a bond with both parents. For Professor Rudolph, the most important thing is that the child is allowed to continue to live the relationship with both parents after their separation. How a decision is made should be determined solely from the child's perspective. Several elements of the Cochem model appear in the new German family law, in particular the accelerated procedure, as well as access to the information that you can use a mediator. All those judges, lawyers, youth counseling centers who are involved should transmit a unified message. So in this way, parental care plans can be created on the basis of joint content. This model should serve as a source of inspiration for other countries. In Croatia, a parental plan is provided under civil law in which all the details are regulated, such as the place of residence, the amount of the time the child spends with its parents, and the amount of alimony. The child is informed about this and expresses his opinion, depending on age and maturity, of course. Mediation is a tool that helps to neutralize a potentially explosive situation, while at the same time helping to make parents aware that both have a responsibility towards their children. Parents have to determine the essential aspects of their child's life themselves and to include them in a parenting plan. The resolution of my report, therefore, arose from all the investigations and discussions that I have had in the course of preparing my report. It calls on member states to ensure that parents are genuinely on an equal footing with respect to their children, ensure that decisions regarding the children's residence are carried out, invite parents to attend mediation sessions, introduce in the respective legislation the principle of double residence as a right of the child and not a right of the parents, except in cases of child abuse, neglect, or domestic violence. The time the child lives with a parent must be adapted to his or her needs and well-being. Take into account the residence mode when granting social benefits. Respect the right of the child to be heard on all issues concerning him, if his age allows it. Ensure that all persons involved in the judicial procedure are professionals, that they coordinate with each other and give the same instructions, therefore having had appropriate training on the rights and needs of children. And promote the development of care plans and to make parents aware through mediation that a double residence can be the best option for the best interests of the child, and to respect the rights of the child that is being heard. I hope from the bottom of my heart to have covered the burning issues surrounding this controversial topic, and through this report we can make a difference. First, by making parenthood more harmonious after separation or divorce, and second, by enabling the practical implementation of children's rights so that a relationship is maintained with both parents. Let's also talk about ideological factors. Although a lot has happened in terms of equality between men and women in recent years, parental leave for both parents, etc., I think that even today most people still believe that a child is better off with its mother than the father. These are clichés, stereotypes about the role of women and men in the family which still exist today in 2021. Unfortunately, we constantly emphasize that both parents should take care of educating children and reinforce that this is good for the healthy and harmonious development of a child. As a conclusion, the interests of the child should take precedence over all other interests. During a separation or divorce procedure, any decision should be made only after answering the question, is this in the best interests of the child? It is not the child's fault that his parents separate and then being obliged to live out the consequences of it, all consequences. To no longer see both his parents so regularly, to have to change residence more often, to renounce many things, this separation that he himself did not want and had to accept. Very often the parents are far too busy with their own conflicts and so are unaware how much the children suffer from the whole thing. I would like divorced parents to choose the mode of life that is most suitable for their child and not the mode of life that suits them best. Thank you for your attention and take care.